Well, good evening, everyone. It's my great pleasure to have this opportunity to introduce my dear friend of over 20 years, Professor Lavanya Rajamani from the University of Oxford. Lavanya is Professor of International Environmental Law at the University of Oxford Faculty of Law. She's also a fellow at St. Peter's College there. And she was formerly a professor at the Center for Policy Research in New Delhi, where she now holds a visiting professorship. Lavanya researches, teaches and practices in the field of international environmental and climate change law. She's authored several books and articles in this field, and her latest book features in the collected courses of the Hague Academy under the title Innovation and Experimentation in the International Climate Change Regime. And her earlier co-authored book, International Climate Change Law, won the Certificate of Merit, the book prize of the American Society of International Law in 2018. The Oxford Handbook of International Environmental Law that she co-edited with Jackie Peel is due out early in 2021. And we're very lucky to have Professor Rajamani here with us this evening to talk partly about some of the ideas from that book. Professor Rajamani also serves as coordinating lead author for the IPCC's sixth assessment report, and she served as rapporteur of the ILA Committee on Legal Principles Relating to Climate Change, and also as a consultant to the UN Climate Secretariat, a negotiator for the Alliance of Small Island States, and as a legal advisor to the chairs of the ad hoc working groups under the Framework Convention on Climate Change. She was part of the UN Climate Core Drafting and Advisory Team for the 2015 Paris Agreement. So it's my great pleasure to welcome you, Lavanya, here at UCL. I'm so delighted. I'm delighted that you're back here in the UK and at Oxford, and that you've kindly given up your time, such a busy term, to come and talk to us today. So welcome, thank you again, and over to you.
Thank you, Ralph, for that very generous and warm introduction, and good evening to you all. It's a huge pleasure and privilege for me to be here with you in this virtual space. My talk today attempts to provide a bird's eye view of the field of international environmental law as it is rapidly evolving, and builds on the work that my co-author Jackie Peel, Professor of Law at the University of Melbourne, and I have done over the last few years on the second edition of the Oxford Handbook of International Environmental Law. The handbook, covering 67 chapters from 70 authors spanning over 1,100 pages, was, as you can imagine, a mammoth project, an intensely rewarding, but also at times intensely frustrating project, but from which we learned a great deal, both substantively and in terms of interpersonal skills. We are indebted to our terrific authors for their remarkable scholarship that has fundamentally shaped our insights into this field, and on which I will be drawing this evening for my talk. The handbook is in production, as Ralph said, and will be out in the spring of 2021. So watch this space in case it's of interest. International environmental law is a dynamic and rapidly evolving field of international law. In the next 30 minutes or so, what I would like to do is to illustrate the profound ways in which international environmental law has evolved since the turn of the century. I will do this first by discussing the changing context within which international environmental law is set and is evolving, which then explains, second, the emerging trends in the normative development of the field, which includes the increasing activity at the interface of international environmental law and other fields of law and policy. This has expanded the sites at which international environmental law is made, applied, and implemented. These are the expanding frontiers of international environmental law, as it were. I will conclude with initial and very tentative reflections on the future development of international environmental law, and conclude by asking the question, not if international environmental law has come of age. This is a question we've been asking of the field for some years now. And I think the answer at the end of this talk, at least, will be perfectly clear that it has. It's an incredibly sophisticated regime today. But I will ask the question whether international environmental law, for all its sophistication and maturity, is actually fit for purpose. Let me turn first to the changing context in which international environmental law is set. The geopolitical, social, economic, epistemic, and cultural context within which international law operates today, international environmental law operates today, has altered in fundamental ways since the turn of the century. First, there are shifts in the underlying scientific knowledge of global environmental harm. Our understanding of global environmental harms, their causes, the interconnectedness of causes and harms, and their impacts on people and the planet is now more sophisticated, complex, and nuanced than ever before. For example, in the area of climate change, which I work quite closely on, an area that's characterized as the defining issue of our age, science has advanced in leaps and bounds in the last few decades. Successive reports of the Intergovernmental Panel on Climate Change, the IPCC, have demonstrated that climate change is real, its impacts are discernible, and that it's occurring ever faster and in more devastating ways than once predicted. Beyond climate change, across a slew of recent scientific reports, from the 2020 Global Biodiversity Outlook titled Humanity at the Crossroads to the IPCC's 1.5-degree report, is the finding that current patterns of production and consumption, population growth, and technological change and development are unsustainable. And in the absence of transformative change, there will be irreversible and unprecedented environmental harm, harm that affects not just human health and well-being, but even the long-term survival of humanity and other species on Earth. In addition to this sort of growing understanding of global environmental harms, there is an increased reporting and public discussion of such harm, triggered in part because of the rapid expansion in internet penetration and the rise in the use of social media. Our senses are continually bombarded with arresting images of starving polar bears and melting glaciers, bleaching corals, sinking islands, raging wildfires, and growing islands of ocean plastic. We have had, like no other generation before us, a profound impact on the environment. And so much so, this has come to be recognized in the characterization of the current epoch as that of the Anthropocene. This recognition has fueled multiple forms of social ecological engagement, in particular transnational social movements, reactive advocacy, radical direct action around global environmental issues. Such engagement, social ecological engagement, occurred in the past, but primarily around local environmental issues. The scale and forms of social ecological engagement have multiplied dramatically in the last few decades. The Extinction Rebellion and the school strikes, for instance, that spread rapidly around the world offer excellent examples, but are no means the only ones. The recognition of our impact on the planet has also inspired a new wave of artistic expression around global environmental issues through eco-art, eco-poetry, music, and literature. Novelist Margaret Atwood's work is particularly compelling and scarily prescient. She asks the ever-pressing questions at the core of our environmental crisis. What if we continue down the road we're already on? How slippery is the slope? What are our saving graces? Who's got the will to stop us? And these are ever-pressing questions in the context of environmental regulation. All these shifts and stimuli have resulted in a third contextual change, in a reckoning of the ethical values, approaches, choices, and conflicts at the heart of environmental discourses. There's been a growth and mainstreaming of diverse approaches and voices in international environmental law, from global south approaches that highlight the exploitative colonial origins of and lingering consequences in international environmental law, to feminist approaches that seek to make international environmental law gender literate, to earth jurisprudence that focuses on the rights of Earth and of all its creatures, and even a nascent conversation on adapting international environmental law to planetary boundaries. Finally, in relation to changing contexts, as the science has become more certain, the impacts more tangible, and the demand for action stronger, the issue of global environmental harm has garnered considerable political salience, much more so than it did in previous decades. Climate change in particular has captured the political imagination in a way that was inconceivable 20, 30 years ago. More than 150 heads of state participated in the negotiations for the Paris Agreement, and successive UN Secretary Generals prioritized addressing climate change during their terms. And it was, remarkably so, one of the decisive issues in the recent US presidential elections. Yet, notwithstanding this increasing political salience, increasing knowledge of global environmental harms, increasing reportage, and increasing direct action around global environmental harms, the challenges of getting to an agreement have become infinitely more complex during this time. In part because of large geopolitical shifts, many large developing countries, India, China, Brazil, South Africa among them, but by no means the only ones, have grown exponentially in the last few decades and are emerging as leaders and innovators in addressing climate challenges, but are also imposing more serious and sustained costs on the global environment. The conventional North-South, developing country distinctions are breaking down. The lines between these categories are blurring. Yet there are persistent inequalities between and within developing countries and between developed and developing countries too. The challenges of poverty, development, and energy access are very real. An estimated 1.1 billion people, that is 14% of the world's population, do not have access to electricity. And an estimated 700 million people, predominantly in sub-Saharan Africa, are projected to remain without electricity in 2040. Such continuing differences between states and their priorities have fundamentally shaped the scope and nature of obligations negotiated in international environmental instruments. More recently, many states, both developed and developing, have been struggling with disruptive shifts in domestic politics, including moves towards populism, nationalism, protectionism, a distrust of experts, alt-facts, and an increased polarization, all of which have had a profound impact on international environmental law as it's evolving. From Trump to Bolsonaro, the effect is profound. And in the now, in the moment that we're all in now, the seismic disruption caused by COVID-19 is also likely to have an enduring impact on international environmental law. The COVID crisis has underscored profound consequences of biodiversity loss and ecosystem degradation for human health, well-being, and survival. It has also exposed the fragility of our systems and demonstrated that abrupt change, whether related to pandemic disease or to climate change or to any other environmental disaster, will affect the poor, marginalized, and vulnerable the most. The response to the pandemic has also accentuated some environmental concerns, such as plastic and other forms of waste, with a dramatic uptick in the use of single-use personal protective equipment, and a dramatic increase as a result in the emissions from the burning and disposal of such single-use plastic and other personal protective equipment. And although the worldwide lockdowns in 2020 resulted in a temporary downturn in energy demand and CO2 emissions, emissions are already on the rise, and COVID disruption could create a serious drag and potentially fatal drag on global efforts to address climate change and other environmental challenges. Even so, there are some positive trends here. The COVID crisis does showcase the ability of governments to intervene decisively and at scale. The ability of governments seems to be primarily dependent on whether they're led by women. This is not just instinct, it's now documented. But the women-led governments have intervened decisively and at scale, and humanity's ability to make fundamental behavioral shifts in response to global crises has been showcased in the recent past. The crisis has also mobilized a range of actors, including civil society, business interests, and investors, to hold national governments accountable for how they recover from these crises. And these developments do hold us in good stead in managing the risks of future environmental disasters. But it is in this ever-changing context and very sort of influential context that international environmental law is maturing and discovering its limits. And the following trends are emerging. I will headline these emerging trends for you first and then proceed to discuss each of them in turn. First, there is increasing maturity in the content of international environmental law. And I will illustrate in a minute the ways in which this is evident, especially in treaty law. Second, there is a move more broadly from treaty making to treaty implementation, and a related consolidation of soft law in the field of international environmental law. There is also, third, an increasing resort to international courts and tribunals. And fourth, a growing decentralization in international environmental law and the emergence of polycentric governance in this field. And finally, international environmental law is expanding its frontiers in its intersections with other fields of activity in international law. Let me address each in turn. Turning first to the increasing maturity in the content of international environmental law, both customary and treaty law. Cases in the last decade have provided concrete content to customary international law relating to the environment, in particular the harm prevention principle. But since treaties play a more decisive role, I will focus on trends in treaty law. The body of international environmental law comprises a very dense network of treaties, including many major multilateral environmental agreements. And although only a handful of multilateral environmental agreements have been negotiated in the last decade or so, there is a discernible pattern in these multilateral environmental agreements. First, there's a shifting focus towards facilitative and catalytic architectures in these instruments and away from more prescriptive architectures. So for example, the 2013 Minamata Convention and the 2015 Paris Agreement identify goals and provide a menu of regulatory options. And this marks a step change from the earlier generation of these kinds of treaties, which were more top-down and prescriptive in their approach to state obligations. Second, there's also a related turn to procedure in these treaties. The 2015 Paris Agreement, for instance, creates a web of interlocking procedural commitments requiring states to submit nationally determined contributions to address climate change, as well as detailed information to clarify these contributions, and as well as to track the conduct of states in achieving these nationally determined contributions. These focus on procedural obligations in relation to transparency. The Paris Agreement deliberately does not create substantive obligations of result in relation to nationally determined contributions. This turn to procedure and transparency certainly has a positive element to it. It enhances governance, legitimacy, and democratic structures in decision-making. But crucially, it also takes the place of substantive standard setting in international environmental law, because substantive standard setting has become increasingly contentious over the years, in part because of some of the changing context that I referred to earlier. This lack of political will for substantive standard setting for international environmental law is substantiated by a third general pattern that one sees in recent international environmental instruments, namely that of greater deference to national sovereignty, circumstances, and capacities. The paradigm shift in the climate change regime from legally binding obligations of result in the 1997 Kyoto Protocol to nationally determined contributions subject to obligations of conduct in the 2015 Paris Agreement is the sharpest example of this trend. And the addition as well of the phrase "in light of different national circumstances" to the principle of common but differentiated responsibilities in the Paris Agreement. A fourth related pattern that is discernible in these more recent environmental treaties is that they reflect greater parity between states in relation to obligations and capture greater nuance in the nature and extent of differentiation between and among developed and developing countries than earlier instruments. So the 2013 Minamata Convention, for instance, contains uniform obligations for states. And unlike the 1997 Kyoto Protocol that contains different commitments for different categories of parties in relation to greenhouse gas mitigation targets, the 2015 Paris Agreement tailors differentiation to the specificities of each of the areas of regulation: mitigation, adaptation, finance, technology, capacity building, and transparency. In some areas, the obligations are largely uniform, procedural obligations in particular, and in other areas such as finance, the obligations are differentiated. In effect, these recent shifts have resulted in different forms of differentiation in different areas, but enhanced discretion for all states, speaking to my earlier point about greater deference being paid to national sovereignty in these most recent instruments. These shifts reflect changing geopolitics between and within countries, especially the rise of large developing countries over the last few decades. Stepping back from patterns in recent treaties to broader emerging trends, the second of the trends I headlined earlier is a move from treaty making to treaty implementation. The focus of international efforts has shifted in recent decades to implementing existing regimes and addressing the regulatory overlaps, inconsistencies, and inefficiencies between and within regimes that flow from a congested legal field. Although only a few multilateral environmental treaties have been negotiated in the last few decades, there's been considerable normative development, albeit of soft law, under multilateral environmental agreements through decisions taken by conferences of parties. Much of this development is directed at interpreting and implementing treaty requirements. Multilateral environmental agreements are often the outcome of consensus-based decision-making and frequently represent just skeletal high-level compromises that need to be fleshed out before they can be operationalized. These treaties often contain provisions that are constructively ambiguous, that allow different states to maintain and preserve their positions, and they often defer contentious issues to be resolved through seemingly less political subsequent rulemaking. Conferences of parties in this context are tasked not just with overseeing the implementation of treaties, which is their traditional role, but also with interpreting the obligations in the treaties and resolving deferred issues. And this is something we've seen in the climate change context with the 2018 Paris Rulebook, for instance, is still resolving some of the issues that could not be resolved under the Paris Agreement. In the process, conferences of parties have become a very important element of the institutional architecture of international environmental law. And soft law, there's the decisions emerging from these conferences of parties, has really consolidated its hold on international environmental law. The shifting focus from treaty making to treaty implementation has also resulted in the strengthening of support mechanisms under multilateral environmental agreements. Multilateral environmental funds in particular have multiplied in the last decade and expanded to include public-private mechanisms such as the Prototype Carbon Fund or the Rainforest Trust Fund. More generally, private finance and enterprise is playing a far more decisive role than before in funding in relation to implementing multilateral environmental agreements. In keeping with this focus on implementation, we also see reporting, monitoring, and review mechanisms have come off the sidelines to occupy center stage in international environmental law. So for instance, in the 2015 Paris Agreement's enhanced transparency framework, it is bolstered by detailed rules under the 2018 Paris Rulebook, and this places significantly higher and more frequent informational demands on states, speaking also to my earlier point about enhanced transparency and a move to procedure in international environmental law. Indeed, the design of the Paris Agreement complements information flow with obligations of conduct in a bid to generate peer-to-peer assessments, mutual trust, and reciprocity, which in turn is expected to enhance ambition and implementation. The third trend that I headlined at the start is the increasing resort to international courts and tribunals since the turn of the century. In keeping with the rapid growth and proliferation of international environmental law since the turn of the century, there has been a rapid growth in the field's judicialization. Over this period, international courts and tribunals have played an important role in the development of international environmental law by providing authoritative articulations of rules and principles and identifying standards and expectations linked to these rules and principles. Regional human rights courts have also begun to weigh in on international environmental law with far-reaching judgments and decisions and opinions emerging from the Inter-American Court on Human Rights in particular. There's also increased use of investor-state arbitration as an environmental protection mechanism and a growing effort to seed and translate norms of international environmental law in domestic litigation. The Urgenda decision from the Dutch Supreme Court being the most prominent recent example of this, but it is by no means the only one, there are many. A fourth broad trend that is emerging is decentralization and emergence of polycentric governance. The last decade has witnessed a dramatic uptick in actors, initiatives, and networks across and within states engaging with international environmental law. The business community, including banks, investors, and insurers, more deeply and constructively engaged in international environmental law than any period in the past. Non-state and sub-state actors, from NGOs to mayors, and even university. Oxford University just unveiled its net zero initiative, are both active participants in shaping international environmental regulation as well as effective vehicles for its implementation. The Paris Climate Conference, for instance, launched the Global Climate Action Portal to record the efforts of non-state actors, and it currently contains nearly 28,000 commitments from cities, companies, and investors. The United Nations Environment Gap Report records that the difference between what states have committed to under the Paris Agreement and the goal, the 1.5 degree or the well below 2 degree goal, can actually be met by these non-state actors and sub-state actors initiatives. And the most telling example of non-state actor influence and reach is that, notwithstanding the US decision to withdraw from the 2015 Paris Agreement, many US states, cities, and businesses undertook to meet the US's nationally determined contribution. So this trend towards decentralization and enhanced polycentricity in international environmental law is in part due to the gaps exposed in traditional international environmental law, together with the difficulties in shifting the entrenched positions of sovereign states. It has, though, in its wake, shrunk the space for international enforcement and expanded the scope for domestic law, litigation, and courts. And we see sort of a tsunami of climate litigation that's ongoing across the world right now. The final trend that I will speak to is this: international environmental law has also dramatically expanded its frontiers in recent years. As international environmental law has grown in ambition and reach, it has encountered other specialized regimes of international law. Some of these encounters have resulted in colliding objectives, as for instance, in relation to legal frameworks governing trade, investment, energy, and intellectual property that have developed largely in silos. Other encounters, as for instance with legal frameworks governing human rights, migration, and disaster, have generated opportunities for convergence, complementarity, and integration. To take one of these examples in a little more depth, the jurisprudence of regional and national human rights bodies on environmental matters has increased exponentially. As these bodies are exposed to environmental principles and sensibilities, they're tapping into a very rich vein of cross-fertilization. Indeed, one of the most path-breaking decisions in international environmental law to emerge in recent times did so from a regional human rights body. In an advisory opinion in response to a request from Colombia, the Inter-American Court on Human Rights went as far as to opine that the jurisdiction and responsibility of states under the American Convention on Human Rights extends to those outside their territory whose human rights have been violated by transboundary environmental harm originating from that state, an effort to deterritorialize environmental action. More broadly, as international environmental law is increasingly encountering other specialized bodies of international law, it has encountered, as I said, colliding objectives. It has exposed different motivations of different fields of law and unearthed new sites of conflict and contestation. But it has also presented valuable opportunities for accommodation and integration. And in the process, international environmental law is expanding its frontiers, demonstrating maturity, and reflecting the real-world complexity in addressing complex environmental challenges such as climate change and biodiversity loss. These encounters have, moreover, multiplied the sites at which international environmental law is made, interpreted, applied, and implemented. And international environmental law is richer for it. I turn now to my final, very brief and tentative section: is international environmental law fit for purpose? The last decade or so has, as we have seen, been a period of rapid, responsive change for international environmental law. The context within which international environmental law is set, as I started the discussion or talk today with, has changed in fundamental ways. It's It has fostered legal experimentation and triggered an expansion in the scope, content, and reach of international environmental law. To recap, in terms of the emerging trends, increasing maturity in the interpretation of the content of customary and treaty law, a change in focus towards facilitative and procedural modes, implementation over rulemaking, nuancing of concepts of differentiation, an enhanced role for soft law, greater diversification in participating actors, and sites of international environmental law activity, including growing judicialization of the field. The frontiers of international environmental law have expanded to reflect a gradual tailoring of the discipline to the nature of the problem that it is addressing, which is complex, polycentric, and intractable global environmental harms. All these changes and shifts flow from the remarkable ingenuity, creativity, and passion demonstrated by international environmental lawyers, diplomats, and stakeholders in stretching international environmental law to its screeching limits to address existential environmental harms. Nevertheless, international environmental law's achievement in terms of environmental outcomes are modest. Both on climate change and biodiversity loss in particular, the jury is in. We are not on track. Much of the field's promise and potential has been explored in these last few decades, and it's fast approaching the limits of its ability to influence state behavior. As developments in the climate change regime demonstrate, notwithstanding twists and turns, and there have been many hairy twists and turns in the international climate change regime in response to geopolitical shifts and legal experimentation and innovation, the international community is still taking a collective leap of faith in the 2015 Paris Agreement, which may well stop short of averting catastrophic climate change. So if the world is actually facing a state of planetary emergency, which every scientific report seems to suggest that we are, it does beg the question whether international environmental law is fit for purpose, and whether for all its sophistication and maturity as a subdiscipline of international law, it is still fundamentally limited. International environmental law, like other fields of international law, is hostage to national sovereignty and political will, and its limits are equally the limits of international law. Against this backdrop, there are clear constraints on what international environmental law can do and can be expected to do as it develops in the future. If international law is to do more, it must move beyond the constraints of the current state-centric architecture and framing and embrace a fundamental reconceptualization of existing models of governance. Such reconceptualization, or at least early signs of it, is underway. It's gaining ground from increasing traction that Earth jurisprudence has received to the judicial efforts to deterritorialize international environmental law, the actions and reactions of national courts and tribunals. Fundamental realignments at the scale required demand imagination. Imagination that is both outrageous and fueled by outrage. It remains to be seen whether international lawyers are actually capable of such outrageous imagination, but the future of the planet hangs in the balance. Thank you.
Lavanya, thank you so much. This has been such a pleasure, and it's a privilege to have you speaking with us this evening. Thank you, and good night to everyone.
Thank you, Ralph, and good night to you all. Thank you very much for taking a little time in an evening to come and listen to me. Thank you very much. I wish it could have been different, the ILA talks. I wish I could have met people in person and interacted in person, but it is what it is for now. But thank you very much for inviting me, and I hope there'll be occasions in future where we can actually have these conversations in person.